Joining me here in studio, Michael Bachner, former prosecutor, now defense attorney. Looks like you went to the dark side there, sir. How are
I think it's the light side.
It's the light side?
Convicted.
Bigger paycheck?
Well, doing my job well.
I hear you. I hear you. Again, we've been following the murder of Jonathan Price, a Marine who was killed protecting his wife during a robbery gone bad. He was shot in the back. That bullet actually exited his heart. We're actually going to hear testimony from a cell phone expert that can place the defendants, according to him, around the bar of that robbery. Take a listen.
So we know that the gun that allegedly was used in this crime was traced to another robbery that these men might have been in connection with. When you have that kind of thing where a firearm is used in multiple crimes and it's used to connect defendants, is that an avenue for the defense to explore, saying, hey, listen, you know, how can we track the evidence properly? Is that an avenue for the defense?
Well, welcome back. The thing with live TV, sometimes things go a little awry. We'll bring that clip up here just a second. I want to talk to Michael here for a second. So we have two defendants on trial right now for the murder of this Marine, Jonathan Price. The defense is weighing in that, of course, the investigators didn't do their job properly. You being both sides of the tracks, is that a common tactic by the defense to just try to discredit the entire investigation?
The answer to that is yes. Defense lawyers will commonly throw stones wherever they think one may hit because you never know what a jury's thinking. And the kind of the corrupting of the investigation technique came to the forefront during the former O.J. case, where the defense was extremely effective in bringing to the attention the dirtying up of the crime scene, the failure to take fingerprints. And we're also living in a world where people watch all these crime shows, and they think everything's supposed to be done the way they see it on television. They're waiting for the Perry Mason moment where the person breaks down and admits guilt. They're waiting for people in their suits with the shoes to make sure they're not stepping on things. So a lot of ways, defense lawyers now have the ability, oftentimes, to try and play that game that they see on TV.
Yeah, and I'm glad you brought up O.J. You made a very interesting point, because one of the witnesses in this this trial here, one of the witnesses that was robbed, actually made some racial statements about they all look alike, and if they didn't all look alike, they would be dead. So do you think that, as a defense attorney, they try to use some type of racial aspect as well?
Well, look, a defense lawyer's job is to bring to the jury's attention all evidence that they think is important for the juror's consideration. I think, although I disagree with the O.J. verdict, digressing a little bit, I think that the defense lawyers did exactly what they should have been doing. And when the police paraded Mark Furman on the stand, who had a history of making racial comments, it would have been malpractice for them not to take advantage of that fact. In the same way here, if one of the witnesses makes racial statements on, I think it was a Facebook page or something.
It was.
At the end of the day, not to bring that to their attention, especially when they make a statement like they all look alike. Well, this is an ID case. If they all look alike, well, you know what? Then you can't ID somebody.
You can't
reasonable
ID.
doubt.
Yeah, makes perfect sense. I do believe, Virginia, if I'm correct, we have that clip up right now. So let's listen to the actual 911 call of Megan Price. She is the wife of Jonathan Price. She was there that night. Her husband was shot. Again, she was shot in the leg as well by one of these defendants, or allegedly by one of these defendants. Take a listen. Very traumatic audio there from Megan Price, 911 call. You heard she mentioned her husband was shot, and you heard that she couldn't get to him. What do you take of this 911 call? I mean, she described suspect descriptions, but right now, as a defense attorney or as a prosecutor, is that enough to say that these two defendants on trial are the ones that did it?
Well, 911 tapes can be really effective, again, depending, this is obvious, on what they say, because they occur contemporaneous or almost contemporaneous with the event. So they're supposed to reflect a very contemporaneous view of what's occurring. So to the extent that there is an accurate description, that's terrific. If the description is not is not what the prosecution would like it to be, for example, the defense's argument is, at a time right contemporaneous with the event, that is the most accurate description, so it can be very effective.
Thank you for that. We are going to cover more of this Marine murder trial here on the Law and Crime Network. Stay with us. Things are heating up. Go ahead and get that coffee, and we'll be right back here on the Law and Crime Network. Stay tuned. Wow, you just heard from the prosecution, $60, a $60 robbery, and Jonathan Price lost his life. Michael, I mean, how do you even justify someone's death over $60? I'm sure as a Marine, someone that serves his country, had these two individuals just came and said, hey, we need money, he probably would have given them money. He's a Marine. That's what he does. He serves his country. And serving your country means serving the community as well.
Well, you know, if I'm the prosecutor, you want to emphasize the $60 just to show the cheapness of life that apparently these defendants exhibited during the course of the robbery, allegedly. The other side of it is, whether it's $60 or whether it's $6 million, it doesn't really matter. It's a human life, and the life's invaluable.
Right.
So the focus I get to show the callousness of their conduct or the alleged conduct, but it's really not really relevant other than to demonstrate. They obviously didn't know how much they were getting before they killed the guy, but it certainly shows the nature of the conduct. And candidly, we live in a world these days where people kill each other for a lot less.
For a lot less. You're absolutely right. I remember a case where a kid that I actually showed up to the scene on was killed over $5. And to your point, it doesn't matter if it's $60 or $6 million. It was still a human life and a life that protected this country. We want to now hear testimony from Debbie Price. She is actually Jonathan Price's mother in this case. Take a listen. You just heard testimony from Debbie Price, the mother of Jonathan Price, a Marine who was killed. You heard over $60 during a robbery where he was shot in the back. His wife, Megan, was shot in the leg. Still with me in the studio. Michael, we were talking during that testimony there, and you said that you would object to actually her taking this stand. Why is that?
I would probably, and I must admit I'm only heard a limited segment of her testimony, but lawyers can make what are known as in limine motions. In limine motions are motions before trial to try and keep out evidence which really serves no relevant purpose. To the extent that mom is being called solely to say that she went to the hospital, saw her son, and was told that he was deceased, and the pain she was going through, that really goes only to sympathy. It may be a sentencing issue if these gentlemen are ever convicted, but it's really not relevant to helping the jury understand how he died. And there's a very fine line judges have to toe and prosecutors have to toe in making sure that the jury hears only relevant testimony and not testimony going to sympathy. So I would have made it pre-trial.
Well, it's definitely not relevant to how he died or the elements of the crime per se, but as a juror, wouldn't you want to hear that testimony? I mean, I understand why you would have that objection, but if I'm a juror and I don't hear from this individual's mother, Jonathan Price's mother, or a victim's mother in a case, it may weigh on how I actually reach my verdict in that case because I didn't have that sympathy factor. What say you?
Well, judges tell jurors that sympathy plays no part in their verdict. And to the extent that sympathy is the reason you're doing it, that's the very reason that they shouldn't be allowed to do it. The evidence is really what controls. Did these gentlemen do the shooting or didn't they? Not whether or not this very, very nice woman who's gone through a horrible time has been, has that type of testimony to give. And candidly, what's the cross-examination of a woman like that other than to get up and say, we're very sorry for your loss?
That is an excellent point. And you made an interesting point that judges say, hey, take emotion out of this. But we know jurors are human. They live for these types of things. You know, they watch all of these TV shows like your Law and Orders and things of that nature. So when you're dealing with humans who watch a lot of TV, who watch these types of shows, it's hard to have a juror take that part out of there. But I think maybe, just maybe, part of why she was called as a witness is because she had to actually go to the hospital. She said he had already passed before he went there. I assume there was some type of identification she needed to do.
Yeah, I mean, the defense can stipulate to the identification and say, we'll stipulate that the gentleman who died is that person without having to call the mom to go through this type of issue. So to me, the sole purpose of calling her, as I understand on my limited observations, was for the sympathy factor. And at the end of the day, you don't want juries making decisions because they feel sorry for people. You want them making decisions just based upon the evidence.
Michael, that is an excellent point. We're going to have more of the Jonathan Price murder trial. We're going to actually hear from his wife, Megan, right after this break. Go refill your coffee and come right back to the Law and Crime Network. Stay tuned.
Here are today's top crime stories trending on lawandcrime.com and across the country. MMA fighter Sergio Hernandez Jr. caught a would-be burglar in his home and put the smackdown on the criminal. Hernandez Jr. can be seen in this video restraining the suspect in a triangle hold until police arrive.
Don't fucking move. I'm not. I'll put you to sleep, bro. Either that, I'm gonna break your fucking arm if you try to move.
The suspect, 21-year-old Fernando Placenia, was arrested and charged with suspicion of burglary. A Harvard law grad accused of murdering his mother with a baseball bat has decided to represent himself in court. 34-year-old Kyle D. Tucker of Hamden, Connecticut, was arrested on one count of first-degree murder and tampering with evidence after he killed his mother, Donna, and burned her body in a fire pit, all while claiming God made him do it. Tucker, who graduated from Harvard Law School in 2009, was ordered by Superior Court Judge Patrick J. Clifford to take a competency test before he decides if Tucker is competent to represent himself. Tucker is being held in lieu of $5 million bond. Convicted MMA star War Machine reportedly is engaged to a pen pal he met in prison. War Machine, who was convicted of sexual assault, coercion, battery by strangulation, kidnapping, and several other charges in connection with the attack on his ex, porn star Christy Mack, met his future wife, 30-year-old Ashley Farrington, through a pen pal program at Ely State Prison in Nevada. War Machine is serving a life sentence with a possibility of parole when he's 71. Unfortunately, Nevada does not allow conjugal visits, so the happy couple will have to wait to consummate their eventual marriage. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
War Machine. This guy's serving a life sentence for the attempted murder of his previous girlfriend. Now this guy's engaged to someone through a pen pal program. And you were telling me that this is actually quite common.
Well, it is. It's odd that it's called a pen pal because I guess that's where he is. But at the
Touche.
But at the end of the day, it is common. You know, even nuts like Charlie Manson had people who were following him and writing him crazy letters and followers. And you have lots of people who get enamored with individuals in jail for a whole variety of crazy, obviously crazy reasons. And I saw the graphic on the screen here. They don't allow conjugal visits in Nevada. So this is going to be, you know, a hand-holding visit with him through the window. I don't know, maybe he's got some money and she's hoping she can get a hold of some of it. Who knows? I don't want to impute motive. She may love the man. But it is a weird scenario.
Hey, I know MMA stars make a lot of money for those fights, so maybe he does have some money, you know, somewhere stashed away, and maybe you can see the happy couple there on your screen. Maybe that's why, you know, she started writing this guy, because clearly not only is he a bad guy inside the MMA world, but if you're putting your hands on a woman, that makes you a very bad guy, and not in the good way. We're going to switch gears, get back to the Jonathan Price murder trial. We want to hear testimony right now from the widow, Megan Price. We heard her 911 call, but now let's listen to her testimony. Pretty compelling testimony from Megan Price, the widow here. She actually talked about she was robbed of the $60 because Jonathan didn't carry cash. Michael, you know, that's pretty compelling testimony. And what got me the most is how apparently they didn't ride in the same ambulance. You had two different victims, two separate transportation modes to the hospital. It's pretty compelling. And she mentioned, you know, the individual in the white shirt. But at this point, do we have enough to point to either Quincinio Canada or Dewan Moslem?
It doesn't sound like we do. And I don't know if she's ever going to be giving the type of beyond a reasonable doubt type of testimony that's ever going to get to that point, but we'll have to wait and hear. But at the end of the day, this is a type of witness, if, to the extent that the defense is that this was a misidentification, you've got the wrong guy, her sympathy is fine with the defense. You know, in fact, I would probably, if I was a defense lawyer, play up that sympathy and let them know that this is not a cross-examination in which we're trying to hurt you. It's just trying to get to the facts and demonstrate so we can try and find out who the real person is, because nobody would want to convict somebody who didn't do the crime. It doesn't make your sympathy any better. So you have to cross-examine a witness like this with nice gloves.
Right.
But at the end of the day, if done right, she could actually be even helpful
Yeah, you have to use kid gloves, but I think she makes a crucial witness in the fact that, yes, a robbery did occur. She was the victim. Her husband, who is now deceased, was a victim as well. And I think everything she just testified to, in my opinion, is very crucial in making a decision in this case. We want to toss back to the courtroom and hear more from Megan Price, the widow in this case, and the victim of the robbery. Take a listen. Wow, we just saw pictures of the injuries sustained to Megan Price. You saw the exit wound of where she was actually shot in the leg. Michael, a couple things here. Obviously, yes, she was shot in the leg, and a lot of people assume you're shot in the leg, all right, you're just shot in the leg. But I've seen people die from being shot in the leg. If you get hit in the right spot and it hits that artery, you bleed out, especially if you don't get help enough. The one thing I always question in this case, how come these defendants weren't charged with the attempted murder of Megan Price? Because when you shoot a gun, the intent is to kill someone. It's not to maim, it's to kill. Why is that?
You know, I can't figure that out either. And even if it's not an attempted murder charge on the grounds that there was no intention to murder, it certainly is a reckless charge or a reckless use of the firearm. So I don't know the theory behind that. But as far as the trial itself is concerned, I guess the issue is if they found that these defendants were the shooters, they would convict of the murder. So maybe they felt that the shooting of her was kind of irrelevant. Right. They wouldn't have gotten any additional time. So there might have been that strategic decision. I don't agree with it because maybe they theoretically could have found they didn't shoot him intentionally, but I would have charged it all. Yeah,
I don't agree either. The other thing, we got about a minute left. You heard there, and we talk about eyewitness testimony and photo lineups. She said, I didn't want to pick the wrong guy. I didn't want to make a mistake. Do you think that will play huge in this decision?
If I am the defense lawyer, that's my summation. Right. Ladies and gentlemen, the woman who was there wasn't sure and didn't want to make a mistake. The prosecution is asking you to conclude that these are the guys. She couldn't decide. She wanted to be careful. How could you convict?
And she was shot in the leg, and we saw that. We are actually going to take a quick break, have more of the Marine murder trial. Jonathan Price, a Marine, was shot and killed while protecting his wife doing a robbery. We're also going to have another guest joining us here on the Law and Crime Network out of Atlanta. Stay tuned. There's so much more to come here on the Law and Crime Network and the Jonathan Price murder trial in the state of Kentucky. Stay tuned. Hey, that was testimony from Andrew Hatfield of the Lexington Fire Department. Apparently, he was the EMT on the scene. You heard him talk about that the male was hurt worse than the female. But, Michael, you and I were talking during that clip, and I think you made a good point. I think he's establishing the chain of custody for Jonathan Price between the location where the shooting happened to the hospital where he was later pronounced dead. So you can eliminate that something else could have happened to Jonathan. Is that correct?
Yeah, I think there, even though I agree with you in one of the comments you had made to me that it seems a little unnecessary to have brought someone like this on, but he is part of the actual story after the death to the hospital where they have to demonstrate that he died as a result of the wounds. And although it's clear the shot killed him, you want to eliminate any argument that maybe something happened that some negligence, for example, may have occurred that could have exacerbated the condition, or maybe his death wasn't caused by the shot, by something that happened by the EMT people.
Right.
So they're eliminating what I think would really be a silly argument to make. But, you know, defense lawyers will sometimes look for silly arguments to make if they think it can get some hay. That's, you know, our job is to look for reasonable doubts.
Well, no argument is a silly argument, right? It's just like the old saying, the only question that's a dumb question is the one you don't ask.
My mom told me that all the time.
Yeah, right. So, you know, I ask a lot of questions. So we definitely want to hear more testimony in this. We're going to go back to Detective Timothy Upchurch. He is one of the lead investigators in this murder. Take a listen to what he has to say. That was testimony from Timothy Upchurch, one of the investigators here in this case. He talked about the serial number of the weapon that was taken in a robbery at the Quality Inn just before this murder. And I assume he's attempting to establish that this was the weapon used. Still in studio with me, Michael Bachner, and joining me via Skype in Atlanta, Georgia, Prosecutor Latonia Hines. Latonia, how are you this afternoon?
Fine. How are you?
Excellent, excellent. So we just heard from Timothy Upchurch. Walk me through what he was doing there during that testimony. I know he was trying to link this gun to this murder that was taken in a robbery. How crucial is this for the jury to hear and for the prosecution of this case?
It's very crucial, especially because what you were talking about earlier about the issues dealing with ID and eyewitness testimony. And so to be able to say that if the defense says that maybe the victim doesn't really know who this person was, maybe she had a problem with it, well, no, there's not a problem because you have a gun that is linked to this person in addition to what she believes to be a person of interest or the suspect. So it's really, really important. Juries like having details. They like being able to put pieces together, and that's what the prosecution's got to do with this case.
Now, David, let me toss to you because we just heard Latonia's take on this. But from the defense side, okay, so you have this serial number to this gun that you say is used in a robbery or in this murder. So what? What does that prove? Does it prove that my clients did this murder because you have this serial number taken in a robbery?
Yeah, right. They still have to connect the gun to the gun that was used at the homicide. Even if they can connect it to the defendant, they still have to be able to connect it to the actual murder weapon. So there's still some steps that have to be made here, but it's a building block case. Prosecutors take step by step and they build it scene by scene, and then they try to come to the ultimate conclusion in the film. And if they can, they can. If they can't, defendants get acquitted.
So what are those additional steps? I would assume you're talking forensics, right? Because, of course, all bullets have striation marks. You know, each shell casing is going to tell you it was shot out of a particular barrel of a gun. So you're talking more of that, correct?
Yeah, forensically to try and demonstrate that the weapon was the weapon used in the homicide. If they were able to do that through the shell casing, striations, like you said, in the bullets. It could also be asking the victim, you know, the type of weapon that you saw being pointed at you. Was it a revolver? Was it a Glock? You know, was it an automatic? Or to give some description. If her description is consistent with the type of weapon they found, that's helpful. If it's inconsistent, that's very harmful.
Got it. Thank you for that, Michael. Much more to come here on the Law and Crime Network and the Jonathan Price murder trial in the state of Kentucky. More testimony. Stay tuned. Hey, welcome back to the Law and Crime Network. We've been listening to testimony from Timothy Upchurch, one of the investigators in Kentucky, regarding the Jonathan Price murder trial. And still with me in studios, Michael, and still with me via Skype, Latonia in Atlanta. I have two questions for both of you. There was testimony during this trial about some DNA evidence, which we're going to hear about here just shortly. Latonia, I'll start with you. The DNA that was found under the victim, Jonathan Price's fingernails, did not match any of the defendants in this case. So it goes back to what you said about the indictment handed down by the grand jury. What would cause an indictment to come out of that when this DNA was excluded? Or do you think it was the DNA was not discovered until after that indictment?
So it's going to be a kind of a twofold issue here. Like the other guest said earlier, it doesn't really take a lot to get an indictment. But I will tell you that DNA testimony, and when you're able to show a link between somebody who's accused and the victim, that's really, really strong. And not having that here does make that a lot harder of a case for the prosecution. So those are the things that the defense has to attack. They attack those things. They attack the things with regard to the ID. But there are still some other things, the linking, and that's the reason why the gun testimony, all of those things are so vital and important for the prosecution when you have this issue with regard to the DNA.
Michael, your defense, DNA is not to your client. What do you do?
Well, if the DNA, of course, you make hay of that, but if the DNA is something that you should have expected to be there, that's one thing. But if the DNA is something that it didn't match, but there's no reason to believe that it should have been there to begin with, the absence of evidence is not necessarily evidence of absence. So it's not, the fact that it's not there doesn't mean that much. But if I'm the defense lawyer and I would have expected his DNA to be in the location where they found it, I would say, ladies and gentlemen, they got the wrong guy. They need to be checking for a person who matches this DNA. It's not my client. Another point in our area, and I would go heavily to town on that and say, ladies and gentlemen, they tested for it because they knew how critical it was. It's not there. Reasonable doubt.
Yeah, absolutely. And I think maybe there's another reason that DNA could have been under the fingernails. We don't know. We haven't heard that testimony. Let's take a listen to the defense and part of their opening statement, and they will talk about DNA and other things. Take a listen. Hey, that was opening statements by the defense for these two defendants in this case, Quincenio Canada and Dewan Muslim, and she made some pretty compelling things there, some pretty compelling points, Michael. She talked about more importantly, that the gun that was used in this murder was not found in the hands of either defendant. It was found by a guy in the hands of a guy by the name of Antonio Fry. So I think that plays a lot into the credibility that these two defendants actually did this crime. What say you?
Yeah, it's indicative of, again, of a lack of connection between the weapon that they found and between these defendants, and that's another point in the side of the defense as far as demonstrating that the prosecution's case is based upon vague guesses and insinuations, and that's what the defense lawyers said in their opening statement. They wanted to solve a very high-profile, tragic murder, over $60, and they did the proverbial rush to judgment. They decided that these were the guys to focus on, and they drew improper conclusions.
Latonia, you're the prosecutor. Hearing that from the defense, especially the part about the gun not being found in the hands of the defendants, how do you bounce back from that as a prosecutor to still convince a jury that these are the two defendants that are charged in this crime, the actual people that did it?
They live you say they live in a world of crime, and that's what they do. Guns, that's the reason why these guns go backwards and forwards between people, but you still go and try to get the link, and you're going to try to link that this gun was used, and it was used by them, and that the way that you do it, I think some of the Facebook posts, those links, you have to try to go piece by piece by piece. If this is a slam dunk case, then we probably wouldn't necessarily be here, but you've got to be able to make the jury make logical jumps that these two defendants are the people who actually had this gun, even though it was found somewhere else, but that gun got into the hands of someone else, but they were the ones on that day who did the crime.
Yeah, I think you made an excellent point. Definitely not a slam dunk case, because otherwise we wouldn't be here. But I do believe that the defense made some pretty compelling points during their opening statement. Speaking of the defense, let's hear cross-examination of one of the key witnesses in this case, Detective Timothy Upchurch. That was cross-examination of Detective Timothy Upchurch with the Lexington Police Department. And I got to tell you, former law enforcement myself, I've been on that stand where the defense is hammering in, trying to question everything in your investigation. She brought out some good points, Michael, here, that he didn't visit the crime scene until a month later. He didn't ask for any DNA. So she's really hammering in, even the fact that he got this surveillance footage from the gas station, but he didn't check on it himself. There's a lot of stuff here that she's hammering in on this detective to try to discredit his investigation into this case.
Yeah, the defense lawyer's job is to let the jury know how they think a proper investigation should be conducted by asking the officer generally what should have been done, and then detailing for what in fact was done, and then to try and argue that the absence of what he did impacted on the believability of the investigation and the search for truth. The defense lawyer is trying to show that what they're trying to demonstrate is that the police officer's failure to do certain things impacts the jury's ability to find out really what happened, and that it's the prosecution's fault that all occurred. So the failure to take fingerprints, the failure to look for DNA, the failure to do certain things, all of that eventually may really be inconsequential, but sometimes the building blocks of all of it grows into this minor issues altogether can become significant.
Yeah, and to your point, each investigation is totally different, right? You don't investigate each crime the exact same way. There's no playbook to murder, if you will, to say step 1 through 25, you have to do it this way in this order.
Correct.
Latonia, let me ask you this. As a prosecutor, and you're listening to this testimony and the defense breaking down this part of the investigation, what's going through your mind at this point?
I mean, this is just standard. What they're going to do is they're going to nitpick at these little things to make the jury think that the investigators didn't do what they were supposed to do. But here's the deal. Even if you went back later to get the surveillance tape and you didn't do it at the time, you got it. And so one of the things that's a really vital link on this case is that you have testimony, you're going to have testimony with regard to the girlfriend of one of the defendants who said that she would normally let one of the defendants borrow her car. So in this grainy surveillance video, you have from one of, I think, the fast food place, a car that sort of matches what she says that she would let them borrow. And you have a timeline. And so you just put all these things together. This car goes through the drive-through at this time. You got testimony of somebody saying that one of the defendants regularly would borrow the car. And the time frame from being through this drive-through and you see this car in this video, then the timeline from when
Latonia, I think you're absolutely right. Timeline is very crucial. I hate to cut you off. We do have to step into a quick break. We'll have more of the Jonathan Price murder trial right here on the Law and Crime Network. Stay tuned. Welcome back to Law and Crime. We've been covering the Marine murder trial, Jeffrey Price, who was shot and killed during a robbery where the defendants only got away with $60. And prior to the break, my guest, Latonia in Atlanta, was talking about a timeline. Latonia, I want you to talk about this timeline because I think it is very important in establishing this case.
Well, I was just saying that's what prosecutors have to do. They have to go and do piece by piece by piece. And so for the jury, they've got to be able to say that it's more reasonable than not that these were the ones who did this because they had the opportunity to do it. They had the time to do it. They're in the same area at the same time that this occurs. You do what you need to do to connect the gun to them, the fact that they have the opportunity, the fact that you've got a video camera that shows some glimpses of a car that they're known to use, and you bring all of those things together so it's all piece by piece, and then at the same time it's this timeline to be able to show that these two were involved with this case, and that's what you have to use as a prosecutor. When you don't have what you would call reliable, clear-cut eyewitness testimony or a clear-cut video of something, of them actually doing the offense.
Right. In the police world, we call that the totality of the evidence. You look at everything that you have as far as evidence, and you tie that all together to come to a suspect and to come to a conviction. We want to get back in the courtroom and hear more cross-examination of Detective Timothy Upchurch. That was more cross-examination of Detective Timothy Upchurch. Michael, I want to toss to you about this whole thing about the lineup, six-person lineup, and the tattoo. We heard Detective Upchurch say he didn't want to be suggestive in that lineup, which is why the tattoo was removed from the face. But if memory serves, and listening to previous testimony, no one ever mentioned either defendant having a tattoo. So I understand his logic where he says he couldn't put 5 other people with tattoos or just one person with tattoos. But why is that even an issue here? Because we didn't have a witness to say, oh, this person had a star-shaped tattoo or anything like that on their face.
Yeah, if one of the defendants has a tattoo and the person who was robbed doesn't mention that the person who robbed them has a tattoo, eliminating the tattoo from the lineup actually is prejudicial to the defendant because it eliminates something that that person said didn't exist, didn't mention. So
Right.
She would have looked at him and said, hey, the guy who robbed me, didn't have a tattoo, or I never mentioned it. Usually what would happen is the police would try and find a lineup with everyone who has a similar tattoos,
Right.
so that they could make it non-suggestive. And the suggestivity of these lineups is very significant, so I don't get it.
Yeah, we can see that tattoo there on the screen of one of the defendants, Quincinio Canada. I think the whole thing was kind of contradictory. Yeah, I'm kind of confused of why the tattoo was even removed from this lineup to say you don't want to be suggestive, but it was never suggested that there was this tattoo. So I'm very confused on that part. I think a lot of us are. We're actually going to jump into a quick break here at the Law and Crime Network. We'll have more testimony in this case. Again, this is the Jonathan Price murder trial, a Marine that was killed during a robbery for $60 protecting his wife. Stay tuned to the Law and Crime Network. We were listening to testimony from Kevin White, one of the workers there at the apartment building where one of the defendants in this case lives, and they were talking about some items that were taken out of a car. Still with me in studio, Michael, of course, and via Skype, Latonia. I want to talk about this really quick. This incident of taking out these items out of the car, to me, was this just a case of people being nosy? I mean, it's not uncommon for people to clean out their cars, throw things away. It doesn't mean that they just did a crime. I mean, if we stopped or we looked at people suspiciously for doing that, I think a lot of people would be getting arrested or at least questioned by police. Latonia, I want to start with you. Why is this important, and how did we even get here with that?
Well, I think what was very great about the testimony that you just heard is that these people seem very credible. They're just going about their day. But you know what? We all have a sense when something doesn't seem quite right, or we're thinking that there's something more, and that's what caused the inquisitiveness, the curiosity. No, of course, we don't want it to be that people just go and just take things out, but they're also the groundskeepers. This is the apartment complex. They're going around it. And so it's not that strange, especially when you have people testifying the way that they're testifying, that they're just doing their normal day-to-day, but then these things pop up, and it's in their mind. And like I said, it's almost like you have spidey senses that you're like, oh, this is kind of strange. And so that's what's happened here, and I think that's how you explain it.
That's right, and with great power becomes great responsibility, as they say in Spider-Man. We want to switch gears and hear more testimony, actually, from one of the defendant's sisters in this case, Nafisa Muslim. She is Dewan's sister. Let's listen to her testimony about this hat. He does stay fresh. That was one of the defendant's sister, Nafisa Muslim. She's Dewan's older sister. She was talking about him keeping these hats and staying fresh. I know both of my guests have to sign off here. Michael, I want to thank you so much for joining me here in the studio. Latonia, I want to thank you for joining me via Skype in hot Atlanta. I will be back there tomorrow. I'm sure the weather is still really steamy there in the humidity.
Yeah.
We're actually going to take a quick break here on the Law and Crime Network and have more of the Jonathan Price murder trial in the state of Kentucky. Stay tuned.